For what purpose does the gentleman from New York seek recognition?
I claim the time in opposition to the amendment.
The gentleman is recognized.
Thank you, Madam Speaker. I rise in strong opposition to this amendment, which would significantly weaken this legislation and damage the collective bargaining process for tens of millions of working Americans. We have said it over and over again today. This bill is not designed to eliminate arbitration. While my Republican colleagues would like you to believe the FAIR Act will end arbitration entirely, that is simply not true. The FAIR Act would put an end to forced arbitration, arbitration that is not willingly agreed to by both sides, which is a predatory, one-sided practice created by and for huge corporations to allow them to get away with abusive conduct. It's a system that can exist only when these companies can take advantage of a stark power imbalance between themselves and workers, consumers, and small businesses. Labor unions correct that power imbalance. The collective bargaining process provides real protections that are unavailable to non-union workers by forcing big businesses to compromise with skilled negotiators focused on improving terms for their workers. Collective bargaining guarantees other important protections in the arbitration process, such as truly neutral arbitrators, better procedures, transparent decision-making, and the option to appeal decisions. It creates a system that can actually resolve disputes quickly, efficiently, and most important, fairly for all parties involved. That is not forced arbitration precisely because it is truly voluntary. Arbitration only works when two parties of equal bargaining power can negotiate terms that work for everyone involved, which is exactly what happens when a labor union and a corporation establish a collective bargaining agreement. This is completely different from forced arbitration of non-union employment disputes, when an employee is forced to accept an arbitration clause that is buried deep inside the fine print of a stack of confusing paperwork on a take-it-or-leave-it basis that they must sign to get a job. But the big corporations love this system because it forces their workers, it forces employees, it forces the purchasers of products to go to forced arbitration. And that's an inherently skewed process, and that is why the employee loses 98% of the forced arbitrations. The employer wins 98% of the forced arbitrations. And that's not a fair process. Moreover, as my colleague, Congressman Perlmutter, made it clear during the Rules Committee meeting on this bill, nothing in the FAIR Act prevents individual workers from deciding to vindicate their rights before a jury. As the plain language of the bill states, no collectively bargained arbitration provision, quote, shall have the effect of waiving the right of a worker to seek judicial enforcement of a right arising under a provision of the Constitution of the United States, a state constitution, or a federal or state statute, or other public policy arising therefrom, close quote. In other words, this amendment is a solution in search of a problem that could upend the rights of millions of workers today. I urge my colleagues to oppose this amendment, to vote for the bill, and I reserve the remainder of my time.
The gentleman reserves.